Yes. Good afternoon. I was just going to take you to the First-tier Tribunal decision and take you quickly, I hope, through the paragraphs where they set out the facts and circumstances which we submit they were taking into account, the tribunal were taking into account when they come to make their assessment at the end, which we'll come to. So we start, there's paragraphs 14 to 17, which explains the genesis of the transaction, and that includes Mr. Horowitz's email about where should BlackRock do debt pushdowns, and the consideration as to whether it should be a limited UK limited company or a US LLC, paragraph 16. One of the reasons seems to be check the box concerns, which is, I've explained. The other, in paragraph 17, may be some concerns from the Office of the Comptroller of the Currency in the US. In any event, an LLC would use. And then, if we move through the recitation of the relevant parts of the documents, which the next part of the decision, and dealing with a question of Delaware law, which doesn't arise anymore. We come on to preparations for the board meeting at paragraph 34. And you'll notice in the middle of the, this is in paragraph 34, there's a note quoted from Mr. Fleming. And there's so I don't have to come back to this, there's a reference in the middle of the note to the business of LLC 5. I don't know if you see that. Will be relatively simple. Hold preference shares in LLC 6, which will only provide for 10% voting control. Accordingly, it will not be in a position to manage any of the underlying US business activities, nor will be called upon to do so. Rather, it will be required to consider its own business of making and managing passive investments and managing its commitments in terms of issuing a Eurobond in order to finance the acquisition. That's the bond to get the loan. That's referred to later on when I come to the commercial purpose argument, referred to by the FTT in its conclusions, the passive business of making and managing passive investments.
Is it to be understood the passive investments there are simply the preference shares?
Yes. Yes. Yeah. So it's just going to hold the preference shares, receive dividends from time to time. And then from paragraphs 36 to 38, we have the evidence about the putative board being briefed on on all of the tax issues, etc. Indeed, the evidence is, as you've seen, that some members of the board were quite intimately involved in planning the transaction with different hats on as directors of other companies. And then we come to the leading up to the board meeting in paragraph 40 and 41, when Mr. Fleming was very keen that Mr. Cushell should attend. I'm sorry, a number of occasions in the past I've got it in my mind that Mr. Cushell was in America. He wasn't. He was in England. I understand that. The problem was it was Thanksgiving, and he didn't want to, I think, be interrupted from his Thanksgiving holiday.
So he wasn't crossing the pond.
He wasn't crossing the pond. The transaction was perhaps crossing the pond, but he wasn't. Not at this time, anyway.
He was at the meeting.
Sorry, he wasn't. Yes, he wasn't at the meeting. Yes, I'm saying he didn't come.
He didn't travel.
No, he didn't travel from the US, which is the point I assumed previously because I was so angry about it. But he didn't. No, he travelled from somewhere in England to attend the meeting. And then we have the what the board were given in advance of the meeting in paragraph 42 and 43. And then it's noted that the meeting took place on St Andrew's Day in 2009. And who attended it, that's paragraph 44. If we could just then interpose by looking at the minutes of the meeting, because that's obviously important. And they're in the final tab of the supplementary bundle, tab 17. And so after the kind of formal paragraph 1, then paragraph 2, the chairman outlined the transactions. And then paragraph 3, we have the discussion. So Mr. Fleming presented an overview of the step plan. And he advised that although the incorporation and the proposed transactions form part of wider arrangements to affect the acquisition in a tax efficient manner, I think this tax efficient manner is always the reference to the obtaining the relief in the UK. Nevertheless, a commercially valid transaction for the company on a standalone basis. So the point he was making was a very narrow one, that if you look at LLC 5 in isolation, this was a valid commercial transaction because it was anticipated on the basis of predictions that more dividends would come in than interest would have to be paid out, so the company would be profitable.
That was the free cash flow analysis we were shown.
Yes, exactly. Yeah. So there was
205 million going out a year and increasing amounts coming in.
Yes, and that was obviously they don't know for sure what's going to come in, but these were the reasonable predictions that were being made at the time on the basis of what profits might be made in BGI and what would be paid up. But it was looking very narrowly at the company as a standalone company without any connection with anyone else. The company formed part of the structure that was to acquire Barclays Global, which obviously is true. And then we turn to tax. A tax opinion be provided by Ernst & Young, supported by counsel, and that Duff and Phelps had produced a fair purchase price allocation. This was the price of the preference shares. It had been advised, I think, by counsel that it was very important that they had the right price for the preference shares, and it was supported by professional valuation.
So
and then,
just to be absolutely clear, that was the price at which the preference shares, well, the amount to be paid for the preference shares.
And then Mr. Fleming updated the board on the UK debt cap rules, which were being introduced in 2010, which potentially restricted the UK tax deduction for interest costs of UK companies. The rules would mean the aggregate UK corporation tax deductions couldn't exceed the external financing costs. Now, the relevance of that, of course, is to the tax relief that would be obtained in the UK. That's what the relevance of the UK debt cap is. And then it goes on, the group had 6 billion of debt. EU had determined a supportable level of debt and interest rate from a UK perspective by comparing key financial ratios with other similar companies. So this was, if you like, a sort of transfer pricing analysis to ensure that the debt, which obviously was a controlled transaction, was at the right level of interest, etc. And these were reviewed extensively by the board to ensure that at the level of debt to be incurred, the transaction was appropriate and commercial for the company. So again, they're looking at this very narrowly as to whether, looking at it from the point of view of the company alone, they could justify entry into the transaction on the basis that the debt out would be less than the dividends in. Result, happiness. And then he goes on to note that the company would gain no benefit from a UK tax deduction for the interest group policy not to pay for surrenders. It's necessary for the transaction to be considered by the board as viable for the company without taking any UK tax advantage into account. So that was the advice that Mr. Fleming gave about how they should approach their task as directors of the company in deciding whether they should approve the transaction. And then the next paragraph concerns, after the acquisition, BlackRock's preeminence within the asset management industry would enable it to obtain financing on the most favourable terms at the top of the range in respect of its peer group. Mr. Fleming did not consider the company's debt amounts, which had been put to HM Revenue and Customs, unreasonable. The structure would give rise to interest deductions between US $50 and 70 million per annum, with a larger interest deduction in December, since the debt cap rules were not in effect during that month. So again, he's talking about the tax effect, tax relief that will be available. And then the next paragraph is all about how they think the revenue will consider them as low risk. Although the proposals were complex, the main purpose was to acquire a complete third-party transaction, no element of tax avoidance. If it resulted in the group being viewed as medium or high risk, there would be increased scrutiny. Noted there were no UK regulatory implications. And then he talks about the effect of the tranche 1, which was due on 27th October 2010. So the debt was issued in, I think, 4 tranches that had to be paid back over different dates. It's all set out in paragraph 2, I think, of the FTT, what the different tranches were. But anyway, he was concentrating it because I suppose it was very imminent on the first tranche. And then the board considered the relative values of the common shares and preference shares. In the paragraph at the bottom of the page, and then Mr. Fleming outlined the unwind provisions, which the company could dispose of the BlackRock Holdco 6 LLC preference shares, and that could be done without tax consequences. And then finally, before we get to the formal resolutions, Mr. Fleming emphasised, although the company was incorporated in the state of Delaware, management and control would be exercised from London, where the company's books and records would be kept. It was anticipated the management board would meet 2 or 3 times each year, more frequently. Again, of course, the significance of that is the tax relief. It has to be have management and control exercised in the UK to be UK resident. So this is confirmed to be an accurate record of what passed at the meeting. What's clear is that, absolutely clear, is that the tax relief was not outside the minds of the directors during that meeting. In fact, quite a lot of the paragraphs, I don't know, the majority of the paragraphs and the topics discussed related to the tax relief. So one can't realistically say that it wasn't in their minds. What, as I understand it, BlackRock do say their cases were aware of the tax relief. They're perfectly aware that was why this transaction was set up, etc. But in taking the decision to enter into the transaction, the directors only took account of the narrow position of the company. That is what Mr. Fleming advised in the second paragraph within paragraph 3. Commercially valid transaction for the company on a standalone basis. So that was what they were addressing. And in our submission, that's not that's not addressing the purpose or the objects or what they were trying to achieve in entering into the loan relationships necessarily.
You're talking here about their case. At some point, you're going to be dealing with what your case was in the tribunals.
Yes.
On this issue and how it was put.
Yep. Yes. I was just taking you through the tribunal decisions.
No, exactly. But
yeah. I'll see.
You'll
but
come to that.
So I was looking at the board minutes interposed at that stage. So if we come back to the findings of the tribunal, and we turn to paragraph 48. Mr. Cushel explained that the relevant entities boards would only be asked to pass the necessary resolutions to implement a transaction if it had been reviewed, refined if necessary, and approved by all internal stakeholders. He saw it as his responsibility as a board member to satisfy himself that a proposed transaction had been, and it's a quote, properly advised on, possesses no risk of reputational damage or other harm to either the entity or myself and my fellow board members. As a board member, I may test a question or a proposal in terms of its anticipated financial outcomes, or to ensure that all relevant regulatory considerations have been taken into account. But typically, I'll be able to take credit that these matters have been considered fully by those responsible for bringing and improving the transaction before it's presented to me. And in paragraph 49, he considered his role as a board member was to be satisfied that a transaction was in the best interest of the entity concerned. He did not see it as part of his remit to begin to question or suggest changes to the underlying capital structure that a proposed transaction should follow. He clarified in cross-examination that what he meant was that while they could theoretically have raised questions about the precise rates of interest, for instance, on the loans, and maybe that they might have been able to change that, perhaps, theoretically. That didn't happen, but that they could have. That it wasn't his role to question the fundamental transaction. That's what he means by the underlying capital structure.
Sorry, when you refer to cross-examination, does that translate into a finding of fact, or do we have to?
Well, the finding of fact is this. He does. I thought to be fair, I would make the point that he did say in cross-examination that he would have seen it as his role in an appropriate case, which wasn't this case, to have perhaps questioned whether the rates of interest might change slightly. So that was what he saw it as, but he didn't see it as his role to question the transaction itself.
Is the FTT, I mean, the FTT here is reciting his evidence. Is it accepting all his evidence? Or?
Well, I think as Mr. Prosser said, they decided he was a witness of truth, so I guess...
Yes, I mean, there's a distinction, obviously, between a recital of the evidence and a finding of fact. I mean, are these factual findings? Or?
Well, I think we're agreed that they've got to be, really.
So we should read the FTT decision as where evidence is recited from Mr. Cushel, it is accepted as a fact by the FTT.
I would submit so. Yes, I think that's. They don't preface all this by saying they make the following findings of fact.
Or at the end say that was his evidence and I accepted all and I find all those things to be true.
But the problem is if you don't do that with all this section, then there's no basis on which they could come to the conclusions they came to later, because they based it on by referring back to what they said before. When they come to the conclusions.
The important thing is you're both in agreement
yes,
that the unchallenged evidence should be regarded as fact, whereas
the evidence that they recite, I would interpret these as being findings of fact that they set out.
But just going back to the point you made about what you said in cross-examination, if we try and...
Oh yeah, yes. In paragraph 9, he does actually he's making the following findings of fact to expand on the statement of agreed facts. So maybe that's enough.
Thank you. Yes, very helpful.
So, Mr. Cushel's position and his evidence was that he didn't see his role to question the transaction. A transaction was presented to them, and while they could look at the details of it and consider whether the interest rate might be slightly different, and then they would have to negotiate that with the other parties. He wasn't sitting down to actually decide on the transaction itself. And then paragraph 51, there is a reference to the meeting not happening in a vacuum. And Mr. Fleming's evidence about what discussions there had been. And then there is what Mr. Cushel said about voting against the proposed transaction at the meeting in paragraph 52.
Could you just read the last sentence?
All right. Yeah. The last sentence, beginning provided the board.
Yeah.
So the last sentence of 51, provided the board felt that the transaction was commercially advantageous for the company, it would not have been sensible to open to the directors to consider an alternative transaction. So exactly, the position they were taking was, we've been presented with this transaction, the whole package, which is both the both ends of the transaction, if you like, the lending and what we're going to invest in, preference shares. We've been presented with all of this. The only question we are asking ourselves is this transaction commercially advantageous for the company? And if it is, we can approve it, because that will satisfy our duties as directors. I think Mr. Cushel referred to fiduciary obligations.
Well, he certainly referred to best interests. So.
Yes, he also referred to his fiduciary obligations somewhere. And I think he also referred to good governance somewhere as well. So what they were doing in my submission was simply asking themselves this very narrow company law style question: can we enter into this transaction properly as directors of the company? And you can satisfy yourself of that by very, very narrowly looking at the position of the company as regards income and outgoings. And if you're satisfied the income will exceed the outgoings on any reasonable estimations, then you can approve the transaction. And that, my submission is exactly what they were doing. That's what they said they were doing.
119 is where he refers to satisfying his fiduciary duty.
I'm sorry?
119.
Yes. Yep. That was where I was going to come next, or at least the whole discussion beginning at 115. But you're right, 119 is important. Sorry. Yeah. So he considers his fiduciary duty was satisfied. That is the duty as a director of the company. But looking at the rest of the paragraph, he said he was comfortable with it and no concerns over its commercial viability. The transaction would have proceeded even if at the last minute the tax advantage had ceased to exist. Now this is a point we'll come back to in relation to the apportionment. But the point he was making was, once you got to the 30th of November, if the UK had announced that they were removing interest relief completely or in some way that would affect the transaction, even then that happened on the 30th of November or at the end, then the transaction would have continued. Now, one might say that's a pretty obvious statement, because as we know, this was an enormous transaction. I think it was described as a juggernaut, something like that. Very complicated. There was lots of moving parts and non-moving parts. So the idea that it would have been halted on the 30th of November because of the fact that the company was not going to obtain interest relief in the UK was obviously ludicrous. So clearly the transaction would carry on. There's no downside to the transaction carrying on, because the structure they created was a structure which would be appropriate for moving the dividends, moving the money up to from BGI anyway. It was perfectly good structure. But that doesn't address the real question, which we'll come on to, which is if there had been no tax relief at all at any stage, would that have existed? Which is, we would say, the correct question to be asking. So yeah, that's paragraph 119. Then 120. And now, Mr. Prosser interpreted the first sentence of this in a very strange way. my submission. It's a fairly straightforward sentence. He's obviously has in mind, the tribunal have in mind Malalieu, because we've been going through that with them. And he's quoting what Miss Malalieu had said, that she had no thought of warmth and decency at the time of buying the clothes. But he makes the point that Mr. Cushell didn't go as far as that. He didn't go as far as that and say that a tax advantage was not an object or purpose of LLC 5. Well, that's absolutely true. He didn't say that at any point. He didn't say obtaining the tax advantage was not an object or purpose of LLC 5. So it's a fairly straightforward sentence and perfectly true. He didn't say what was the purpose, but he didn't say it wasn't quite correctly. However, adopting the reasoning of the House of Lords in Malalieu, as further explained in Vodafone, it's necessary to look beyond the conscious motives of LLC 5. By that we mean the motives. By that they mean the motives that they expressed, if at all, in the board meeting, and take account of the inevitable and inextricable consequences of entering into the loan relationship. And then they say, and the tribunal says, having regard to all the circumstances of the case, it's clear that the securing of the tax advantage is an inevitable and inextricable consequence of the loan between LLC 4 and LLC 5. So having looked at all the facts that I've taken you to, in my submission, that is an inevitable consequence. Looking at the background to the transaction, the whole background, this was an inevitable consequence.
Well,
which is not
the point has been made, as I understand it, is that the test is not what the consequences are, but the sense of the sentence, I suppose you might say, is that securing of a tax advantage was an inevitable and inextricable and intended consequence.
It isn't exactly, yes. It's intended because it's an inevitable consequence of what you did in the context of the circumstances of the case. And, most importantly, in the next sentence, it's not merely incidental. Because that is, in a way, the most crucial part of all this. Obtaining the relief may well be a purpose in a lot of transactions. Maybe it'll be an incidental, inevitable, and inextricable consequence in all loan transactions. But in many transactions, it's merely incidental to the commercial purpose. Because if you borrow money commercially to buy something, it is an inevitable and inextricable consequence that you will get debit relief. But that is incidental.
Well, okay. Can we?
That's the point.
I think we need to then. Can you help us in your submissions with exactly what you mean by incidental? Because it's all very well using an example of, well, you go to the bank because you need money, but there are many structures that aren't that straightforward. Let's say LLC 5 was not in the structure in the old way. This was let's assume it was a UK target. It was funded partly by debt, partly by share capital from its parent company. What of that situation? It needs the money, but one of the elements that may quite legitimately go into the choice of the method by which the company is funded will include tax, because you have to do the financial calculations. Are you saying that's also incidental?
Well, it may be. I mean, this is a factual conclusion that the FTT has come to.
Yes,
on all the facts of this case.
But we're having to articulate the legal test.
Yes. Well, I don't think you can articulate a test as to whether it's incidental in all the circumstances. That's perfectly good. That is the test. It's applied. Whether something is incidental is crucial as to whether it's a purpose or main purpose, or whether it's not. I mean, it is the legal test that is applied by courts. They will say something is incidental or not incidental, depending on the factual circumstances. So,
I do think we need to tease out, like my lady says, what that means. what does it mean to say, because you accept that there are very many transactions entered into for good commercial reasons, but which inextricably and inevitably have tax consequences, and it's artificial to suggest that they're not in the minds of those who are entering into transactions. What does it mean to say that they're merely incidental?
To the commercial purpose. Well, you first have to identify, by looking at the facts, what the commercial purposes were. Lady gave an example. And then you've got to weigh up whether obtaining the tax relief was incidental to that, or whether it was a separate, independent purpose of his own.
That doesn't. Yes. I don't find the language of inevitable and inextricable consequence, which is taken from what Lord Justice Millett said in Vodafone, I think, a particularly helpful test for distinguishing between the case where the reason you're doing it in the first place is a tax reason, and the reason you're doing it in the first place is a commercial reason in which the tax advantage is just an advantage that comes with it.
But I don't think this that approach is really is going to answer that question. It's the further analysis as to whether that is incidental to the other purpose that's really going to answer it. And the same problem would arise if, let's suppose, the board had factored in this case, which they could have. They could easily have done the opposite. They could easily have not done what Mr. Fleming advised and said, well, we're taking account of the following factors. The fact that there's more income coming in than going out, but also the advantage, the tax advantage to the rest of the group. Perfectly legitimate thing to take into account. If they'd done that, I don't think there'd be any question that you would then have to decide whether the tax purpose, because on anybody's argument, even Mr. Ross's, that would be a purpose, was incidental to the commercial purpose in any particular case. That's a necessary part of any analysis of this kind of transaction. The fact that we're getting to the purpose, you might say indirectly, by looking at what the inevitable and inextricable consequences doesn't really affect the fact that this question is going to be asked.
Well, I would have thought, without the benefit of any authority or any analysis, just as a matter of language, if you ask what somebody's purpose is in doing something, you're asking why they're doing it. I don't think you answer the question why you're doing it as to what the inevitable consequences are. Because they may be desired consequences, they may be incidental consequences, they may be unwelcome consequences. The fact they're inevitable doesn't tell you why you're doing it. Why you're doing
maybe
it may be a different question, isn't it?
Well,
I mean, I think what you want to say is, despite what Mr. Cushell's evidence was, the real reason why they did it was because it was part of a tax-saving structure. Isn't that what?
Well, it depends who you mean by they.
The directors of LLC 5. And the difficulty is that what if Mr. Cushell's evidence.
If you mean by that, why did they approve the transaction? I absolutely accept he approved it, taking account of the factors that we've discussed. My point is that's not the same. That doesn't tell you, necessarily what the purposes are of the transaction, because you can have transactions that you enter into. You decide to enter into them for particular reasons because you satisfy particular criteria. But your purpose may be something else in entering into the transaction. That simply doesn't answer the question.
Can I just clarify, because I think this was common ground before the parties below, and I think it's also in the skeleton argument. You're not taking issue, as I understand it, with the approach in TDS of looking at the subjective purpose of LLC 5 in entering into the loan relationship. Have I
Yes,
understood that?
not at this level, certainly. I think we're bound by TDS.
Okay. So,
Yes.
so TDS para 41, or whichever paragraph it is in this court, not controversial in terms of its
Yes.
applicability.
But that we submit brings in the learning about purpose and subjective purpose, which I've been taking you through. And there's no doubt that the House of Lords has said several times that the inevitable and inexorable consequence of what you do can be a purpose.
Well, can be. There may be a difference between can be and
Yes.
necessarily is.
Well, the further factor that I was going to just go on to was that this was an inevitable and inextricable consequence, which was actually intended by the directors. It wasn't an accidental consequence. It wasn't something that came out that they didn't know about or just happened. This was something that they
or that they were prepared to put up with because they had other reasons for doing it, and it's just one of those
No,
things.
no, I'll go further than that. They intended that this consequence to happen as directors of the company, because they discussed, we know from the board meeting, that they discussed the tax consequences. They didn't take it into account in deciding to approve the transaction. I quite accept that. But they intended it to happen. And they knew about it, and they discussed it, and they intended it. It was something they intended. So you may be right, it may not be all inextricable consequences. Although, I don't know about, Malloy and Drummond rather suggests that anything that is an inevitable consequence of an expenditure would likely be a purpose. It doesn't really suggest that Miss Malloy, you had to be intending warmth and decency. It's just assumed, I suppose, that you did.
I don't think it's put like that in Vodafone.
No, it wasn't. No. But in deciding what the inevitable consequences of the transaction are, you have to look at how the transaction was set up, etc. You can't just look at the position on the 30th of November 2009. Look at the transaction. You have to understand the background to it, which the board would have to do as part of their job. They did know. We know they did know what the background was. They were actually involved in it. But they would have to know what the background was to the transaction. So there is more to it than just inevitable and inextricable consequence. It is one that was actually in the minds of the directors and one that they were intending to happen. And we know they intended to happen because they then claimed the relief.
Do you go so far as to say they wanted it to happen?
Well, I'm sure they did, yeah.
But is that
Well, they were discussing, for instance, how it would be restricted by the worldwide debt relief rules, etc. They were discussing the fact that they had to have their meetings in the UK in order to get the relief. You know, central management control had to be in the UK. That was being told to them in the meeting. So there was a lot of discussion at the meeting about matters relating to the tax relief.
Do you have factual findings that this was something that they positively wanted to happen?
Well, difficult to know what that means, really, in the context of a group of companies. I mean, it's not their money, so maybe you might not mind one way or another.
But I mean, to be clear, we haven't got.
But the company wanted it to happen.
Yeah. I mean, we've got the FTT's conclusion of a tax main purpose, but it gets there via a reference to Nugee and Drummond, and doesn't really.
Yes.
It doesn't elaborate on any of the points we're discussing now.
No, it gets there by Malloy and Drummond, which we would say is the correct approach to adopt. Can't be wrong to look at House of Lords authority on subjective purpose. Everyone agrees this is a question of subjective purpose. And I agree that their reasoning is compressed, to say the least. But they do refer to all the circumstances, which refers back to the facts that I've set out. So they could have set them all out again, I suppose. That might have been better and explain why they came to the conclusion. So there is a similar problem with all the three decisions that they made, in fact, because they were all very compressed. And the decision about commercial purpose is even more compressed than this. Look in the next paragraph, it's essentially one or two sentences. But the question that you have is, well, did they err in law? And was this a decision that they weren't entitled to come to? That's what you have to decide on appeal, not whether you'd have come to the same conclusion or etc. So you have to identify a way in which they misdirected themselves. My submission, they didn't. And did they come to a conclusion that they couldn't come to on the facts? Well, for the reasons that I've stated, they came to a conclusion that they could come to on the facts. So for Edwards and Bairstow to attack like this, it's not good enough to say, unless you're saying that they didn't adequately reason the decision. I don't think that's been argued.
Is this an Edwards and Bairstow attack?
Well, assuming I'm right that Malloy and Drummond is the correct approach, they're left with Edwards and Bairstow then, because the tribunal have correctly directed themselves as to the law. So the only way that you could then attack their decision is by saying that they came to a decision that no reasonable tribunal could have come to. Of course, if you think they've erred in the law, that's a different matter. Now, what the Upper Tribunal did was decide that they had erred in the law in the Malloy and Drummond, and then in a sense remade the decision.
I saw that in your skeleton. I just cannot see that they have gone through the process of remaking. They say
Not formally, but
no. They say it wasn't a material error, which is a very different thing.
And they explain
an error of law.
Yeah, they explained why it wasn't material by looking at all the facts.
There's no indication that they were making additional requirements. So I do, for me at least, have a problem with that.
Yeah. Yes, I see that that's the way they put it, but they then went through all the facts, which would come from the FTT decision, in their decision. They reviewed all the facts that had been found, which we've been looking at, and looked at it from a slightly different angle, but came to the same conclusion in the end. I mean, it may have been, I don't know, the dispute may be more formal, that they thought that they weren't entitled to rely on the case law in relation to holding exclusively, and that they should have simply concentrated on case law on this particular provision, which is what they did. But they came to the same conclusion in the end. So it may be that their difference is more formal than real, my submission. In any event, whether the Upper Tribunal were right or not, the question that you have is whether the First-tier Tribunal erred. In coming to the conclusion they did on these facts. And the only way that you could come to that is by, in my submission, is by deciding as a matter of law that they had to decide that the only matters which were purposes were those which were taken into account by the board in deciding to approve the transaction. If you conclude that as a matter of law, then you can overturn their decision, I guess, because then they're limited to what the tribunal, the board decided in approving the transaction. But as long as that's wrong, and I would submit that's plainly wrong, then there's no grounds to overturn this decision. On the basis of the law as it stands. And I take all the points that have been made that it's possible that this provision ought to be considered by a higher court, perhaps untrammeled by all the authority that is built up around it. But that's not for today. So I think unless there are any further points, I will move on to just and reasonable apportionment on the basis that for the moment, that there are two purposes that have been found, the tax avoidance purpose and the commercial.
Are you leaving unallowable purpose? The main strand of that.
The main strand. I was going to come back to the commercial purpose.
Right. I just want to follow your course. At some point, you remember I asked you to help us as to what your asserted case was at the various prior stages in relation to the issue that you've just been discussing about purpose.
Right. I think it's been the same. I mean, it didn't change between the First-tier Tribunal and the Upper Tribunal.
Yes. Can you just take us to somewhere which encapsulates how you put it, how you then put it? I'm not suggesting you're putting it differently. I just want to know what they had to consider.
Yes, it's interesting. They don't actually set out.
No, well,
our submissions in the decision. They set out the Mr. Prosser's contentions.
Yes, well, we've got various skeleton arguments scattered through the papers. I don't know whether.
I don't think we have the First-tier Tribunal skeleton.
No.
We have the Upper Tribunal skeleton. I think it's in the papers. I mean, in the Upper Tribunal on this point, to refresh my memory, we were essentially saying that in the Upper Tribunal, we were seeing the First-tier Tribunal were correct in that approach. We weren't saying that they were wrong on this point.
But you were presumably defending the application of Nugee and Drummond in the Upper Tribunal.
Yes.
So something must have been said about that because the UT rejected that.
Well, that was Mr. Prosser was saying it didn't apply.
Yes, so they rejected your position.
On that point, yeah. But they went on to decide that they could come to the same conclusion without the assistance of Malvey and Drummond and McKinley. That seems to be what they did.
If I can help, it's 153 of the Upper Tribunal onwards.
Thank you. Yes, but I don't think there's any reference to the revenues case.
Yeah, that's your case, isn't it?
I mean, I would like.
I think there is a reference to. I mean, before that, they seem to be saying what I was arguing. From 138. Well, that's on commercial purpose, actually. Sorry, no, that's my argument. Commercial purpose. Yes. They seem to have simply summarised the arguments of the person who lost in each case. So as I can see, they summarised my arguments on commercial purpose and then rejected them, and they summarised Mr. Prosser's arguments. And then
accepted them.
Accepted them, but sort of, yes.
I mean, if I intervene, I don't know whether this Mr. Ewart is going to finish in time for me to make my reply submissions today, but if not, then I would be happy to provide first thing tomorrow the skeleton arguments at the FTT level, so you could see how the unallowable purposes points were being put.
Yes,
in
well,
terms
on our undertaking not to read them except for any paragraphs that you specifically point us to. Yeah. Perhaps that could be done overnight.
But I'm not quite sure. Were you wanting to know that because you thought that the arguments were different?
Well, I think we were, some time ago, I think Mr. Prosser was addressing the point that you were seeking to, he was making he was contending that effectively you were seeking to go behind not only what the FTT found, but what your own case had been in relation to purpose. That's what I gained, rightly or wrongly, from the submission, so it better be, if it is a correct understanding, it's your opportunity to disabuse us of that.
Right.
I mean, I see in paragraph 139, which falls under the eye because we've just been taken there. The Upper Tribunal understood the point that you were making at that stage, but in the context of commercial purpose, about what it was that the board was doing. But it doesn't seem
That's
to be in another context.
sorry, 139 of the FTT. No, Upper Tribunal.
The Upper Tribunal, it's page 123,
Yes.
para 139.
Yes. I think that was what I was saying. Pretty sure that's what I was saying before the FTT and what I'm saying before this court. All the board minutes revealed is that they approved the transaction as being regulatory compliant, not adverse to commercial interests, commercially viable. That's exactly the point I've been, I'm afraid, banging on about here. But I'm yeah, well reminded, but I thought that was the way it was argued in the FTT as well. I'm pretty sure. Let's look at the transcript overnight and see what Larry Friend was saying about it, in contrary to our case. So then, can I take you to just and reasonable apportionment? And as I indicated, the approach of the first-tier tribunal, which can be found in paragraph 121 and 122 and 123. So they conclude that there are two purposes. They then say that they're going to apply the approach of Judge Baer and Oxford Instruments. And then they say the evidence of Mr. Cushell is that LLC 5 would have entered into the loans, even if there was no tax advantage in doing so. Now, what Mr. Cushell, what that's a reference to is whether they would have entered into the loans on the 30th of November, at the time of the meeting. And you can see that from the evidence found in paragraph 53 of the FTT decision. If you look at paragraph 53, you'll see Mr. Cushell also said if the anticipated tax benefits of structuring the acquisition had for any reason fallen away, it would have been too late to revise the structure and the acquisition would have gone ahead as planned. So the point that Mr. Cushell was making was, by that stage, if the tax...
So you said that's neither here nor there.
Sorry?
You said that's neither here nor there.
We said it's neither here nor there, exactly.
I mean, but by that stage it was all too late to pull out.
Exactly.
Okay, can I again interrogate that a little more? Because this was the first board meeting of LLC, right?
Yeah.
It's only just been formed. So to the extent you're looking at everything that's happened earlier and saying really it's too late to pull out, how does that inform the application of the test, which you say in this court you have to apply, which is LLC 5's purposes of entering into the transaction? It only reaches that decision on the one occasion it thinks about it.
Yes. can I draw a distinction? What we accept is that in determining the purposes, that you apply a subjective test. But what we then say is that when you then, having determined what the purposes are, when you're looking at the question of just and reasonable apportionment, that is a fully objective test. I think that's accepted. It's an objective test. And you're entitled to look beyond what's in the mind of the directors of the company in determining, having decided these two purposes, you've got the debits, you've got to apportion them between the purposes on a just and reasonable basis.
Well, yes, I mean it's quite difficult to conceptualise this because if LLC 5's appeal fails on this point, on the first point, so there are two purposes, essentially you've won on the revenue of one as to there being two subjective purposes. So do you need to go that one stage further then and say, in determining the just and reasonable apportionment, we then go outside what was in the minds of the directors? Because you've already got two main purposes, one of which is tax.
But then you have to carry out a just and reasonable apportionment.
And it's
between the two.
accepted by LLC 5 that that apportionment has to be on an objective basis. But nonetheless, they say it's constrained by the two purposes.
Yes.
So
I'm not quite sure
to
exactly
help
what
us with that.
That mean? Well, I'm not sure I can help you. I would say it's not in the way that they've described it. And the way that courts have approached this in the past, I think there are two courts, Court of Appeal have approached it, always very briefly. There is TDS, which Travel Service, TSD, and there is FIDEX.
Yeah.
And FIDEX is referred to.
Have we got it
In
in the
the-
bundle?
I'm not sure we do actually. I don't think
No.
we're trying to keep it down, but the relevant part is referred to in the Upper Tribunal decision. Yeah, yes, Judge, yes. Well, Judge Beer adopted it. So they've all adopted the approach of applying a but-for test, essentially. Although they say that's not necessarily the test. In the end, all courts, QuickFit as well, have adopted it. They've all adopted a but-for approach, which is to ask the question whether the debits would have existed but for the tax scheme, essentially.
But it's a cross-check, isn't it?
Well, they say it's a cross-check, but they haven't actually applied anything to cross-check, as far as I can see. They just leap straight to that, and it's usually done. Been done very briefly, as I say. In FIDEX, the summary here is virtually the entirety of what Lord Justice Kitchen said about it.
Where are you taking that from?
It's
Do you see
the
in this case?
paragraph 193 of the Upper Tribunal decision. He says, where the company and a mixed purpose have been party to certain bonds, but all the debits arising in respect of them were allocated to the tax purpose, because they would not have arisen absent the tax avoidance scheme entered into by the company. So that was the way that Lord Justice Kitchen decided that. And he didn't say very much more than what's quoted, what's summarised there. Actually, it was a couple of sentences at the end of the judgment. And there's a similar approach in the travel documents case, which is in tab 12. This is on the LGI appeal. There were two appeals. One was all about unallowable purpose, and the other was simply on the apportionment question. And the argument was run there on the basis of the but-for test. You see, Mr. Mr. Peacock in paragraph 51. His thesis was essentially that for the purposes of paragraph 13.1, debits should be attributed to the unallowable purpose only if and to the extent that they would not have been incurred but for the tax planning. Now the problem the taxpayers had there was that they couldn't prove, they hadn't got the evidence to prove what would have happened but for the tax planning. So they failed, but the approach that was being adopted was exactly the same. And as Mr. Prosser rightly points out, Judge Beer in Oxford Instruments adopted the same approach. It's a rather odd case because he had already decided against the taxpayer, and then he went on to consider if he was wrong about that counterfactually, what would have happened. So his consideration of the unallowable purpose of the apportionment is actually in a sort of obiter part of the judgment, rather very odd. But he applied the same approach, which was to ask would they have existed but for the tax scheme essentially there. But what he wasn't doing was what the FTT did in this case, which was looking at the end. He was looking at whether essentially the tax scheme would have existed at all, or this part of it, if the relief had not been available. So he was asking the question, well, let's go back to when they constructed this scheme. Would this particular loan relationship, which was part of the scheme, have existed if there had been no tax relief? And his answer was no, it wouldn't have existed. So that's the approach that they've all adopted, all the courts have adopted so far. Now you're right, my lord. The Upper Tribunal in this case set out a slightly different test, I think, but then said that it was a helpful check to consider the but-for approach. And that's paragraph 191. The approach that they put forward is in the middle of paragraph 191, where they say the correct approach is to determine whether the reason the debits existed was in order to obtain a tax advantage on the basis of an objective consideration of all the relevant facts and circumstances. And then the next paragraph, they consider why the FTT was wrong in its approach. And then they go on to say, immediately, depending on the facts, it may also be helpful to check the just and reasonable apportionment conclusion by applying a but-for test, see QuickFit. And this is similar to the Court of Appeal's conclusion in FIDEX. Now in FIDEX, it wasn't expressed to be a cross-check, it was just the way the court decided the case. And then they agreed, in 194, they applied the but-for test, essentially, agreeing with me that the creation and insertion of LLC 5 into the structure and the loans approved by board members would not have been incurred but for the tax purpose. Then they said, which I would suggest is important in the cross-appeal on commercial purpose, the commercial purpose was a byproduct or consequence of the tax-driven decision to place LLC 5 in the acquisition structure, which meant they received a commercial benefit from the deal. But this was all a consequence of the tax purpose without which no deal or benefit would have been obtained. The commercial purpose of LLC 5 and the loans would not have occurred but for the tax purpose. We would submit they were right about that. But what also follows from that is that we would submit that the FTT were wrong to consider that there was a commercial purpose in this case. I'm just going to come on to that briefly in a moment. I thought I would just take you to as we were passing. Despite the FTT stating that it was applying the approach outlined in Oxford Instruments, if it had done so, it would have asked the question, would the loans have existed at all if the benefit of tax relief had never existed? The answer to that question is objectively no. There would have been no LLC 5, no loans if the UK had not provided tax relief for interest in these circumstances. And the reason they say it's objectively obvious is because everyone admits that the only purpose of it was to obtain the only purpose of having LLC 5 and the loan relationship between it and LLC 4 was to obtain the tax relief. So we submit the correct approach is not to focus on the subjective purposes of the parties when you're deciding on the just and reasonable apportionment, but to look more widely at all the circumstances.
So you said the UT applied the right test?
They applied the right test.
Or articulated the right test?
Yes.
Because that's what they say in 191.
They set out a test in 191. They then apply, they don't appear to attempt to apply that test,
Okay, but
other than the cross-check.
That's the test you say it is?
Yes. Well, it may well be said that what they call the cross-check is actually the correct test. And that's the way it has been, the way it's happened in every case, I think. But I can't quibble with the test set out in 191. Just, I'm not quite sure how you do it other than by applying the but-for approach that they did actually apply. It may be that in most circumstances, they do say depending on the facts. So it may be that there are some factual situations where you can apply an other than a but-for test. In this situation, but-for test would be appropriate. That may be what they're saying.
And your but-for test, at least as applied by the UT, goes beyond the existence of the loans because it expressly includes the very existence of LLC 5.
Yes, I'm not sure it's necessary even to go that far, because the important question, as Lord Justice Kitchen said in FIDEX, is to concentrate on the debits.
Absolutely.
The existence of the debits. So if you, as long as you can say that the loan relationship would not have existed, that's as far as you need to go. They did go further, and clearly they're right on the facts of this case that LLC 5 wouldn't have existed either. But that's not a necessary part of it. There could be cases where the company would have existed, but simply wouldn't have entered into the loan relationship. So I think they were simply making a factual point about this case. Can I just say something about the alternative cases? They assume that it's wrong. I think they must assume it's wrong to ask this question. The but-for kind of question.
No, we're happy with but-for.
Oh, they're happy with but-for, right?
Just for whose purposes?
Sorry.
We're not happy with moving away from the company.
Right. Well, in that case, I'm not. It's another problem I see with it. I'm not really clear how the kind of apportionment that they're suggesting fits in with a but-for test. In any event, there are a number of problems. Their first approach is to rank importance, or I think is what they seem to be saying. But that is self-evidently a question of fact for the First-tier Tribunal, not a matter to raise in the Court of Appeal and ask this court to determine as a matter of fact. Which, even if it were the correct approach, you couldn't be asked to do it at this stage. It wasn't raised, as you know, in the First-tier Tribunal. So it's an impossible point to raise. But in any event, there doesn't seem to be there's no principled reason for basing an apportionment on those factors, i.e. either relative importance, presumably to the company, be a subjective guess test. Or on the amounts that they anticipated, they say they would have obtained at the time, although wrongly, and they subsequently discovered was wrong. There's no way of saying that, there's no principal way of determining that these amounts, the amounts which are attributed to the importance of the commercial purposes, or the amounts which they wrongly thought that they couldn't claim, are attributable to the commercial purpose any more than the amounts they did claim. Because you have to apportion these things between the two purposes. You have to determine what's attributable to each, we would say, attributable to each purpose. And you don't do that by asking how much did we think we were going to get at the time when we entered into the scheme compared to what we actually got subsequently.
But how do you say we should do it? Because the cases haven't really gone further than in reality an all or nothing, as you said,
Yes.
up for approach.
I think that is the correct.
The legislation anticipates that there may be an apportionment.
Yes, in some cases there would be.
Other than all or nothing.
Yes. Well, I mean, the only, I think maybe the only example is QuickFit, where there was an apportionment between the interest that had existed on the commercial loan and the extra interest that was added. So you haven't looked at QuickFit, but essentially they had loans which had been set up for commercial purposes. They then substituted in a loan at a higher rate of interest for an allowable purpose. And it was held that they could, at the moment, the Upper Tribunal held. This is one of the cases my learned friend mentioned is coming to this court. Actually, very soon, 16th of April, I think it's set to come. That was the way the Upper Tribunal approached it. They said we can apportion because the interest that had been paid under the commercial, we know it was a commercial transaction already at an interest rate. What they did was they just increased it. So it was only the increased amount that was attributable to the tax avoidance purpose, because that was what they increased it by from the commercial. But we don't have that kind of circumstance in this case. You can't say the part of the interest was commercial and part of it was tax. In a sense, all of it was commercial, all of it was tax. It was fixed on a commercial basis, but it was all incurred for a tax purpose on the assumptions we're making. So there's no principled way of, in my submission, of splitting it up. So the two methods, one is relative importance. Well, that just takes you back to subjective questions, inevitably. It leads you to arguments about how important it was to whom. And then you just end up carving up the amount artificially in that way. The amount that they anticipated, well, in my submission, the answer to that, simple answer to that is that they anticipated they would get what they were entitled to under the legislation. And that's always the case. They would anticipate reasonably that they would get what they were entitled to. Now, they made a mistake initially. They thought they were entitled to less. But that doesn't change the objective fact that they were anticipating whatever they would get. That would be the same if, for instance, the law changed subsequently. So it wasn't that they made a mistake, but there was a change in the law which allowed them to claim a larger amount. Or alternatively, a situation where the loan was on a floating rate, and so the interest rate increased. they would automatically be able to claim more because the amount that they paid was increased. But you couldn't say, well, we will disallow the amount at the beginning because they knew they were going to get that, but we'll allow the extra amount because the interest rates have increased. I mean, that wouldn't make any sense, and would be an inevitable consequence, I think, of this kind of approach being adopted. So finally, unless there's anything more on just and reasonable apportionment, and it may be that maybe this court will take more time over just and reasonable apportionment than the previous courts of appeal have. Commercial purpose is the final topic. This is quite short. The relevant finding of commercial purpose is at paragraph 121 of the First-tier Tribunal decision. So the first sentence is referring to the tax avoidance purpose, carrying on from the previous paragraph. And then the next sentence is making a finding in relation to the commercial purpose. They say the evidence is that LLC 5 entered into the loans in the furtherance of the commercial purpose of its business of making and managing passive investments. This too is clear and important purpose, such as the main purpose. So that's it. And we submit that what the tribunal is referring back to is paragraph 34, which I showed you. There was evidence that it was a passive business. That's the reference to the business of making and managing passive investments. Now, we submit that the only findings of fact in relation to the purposes of the board, the commercial purposes of the board, where, as I've said before a number of times, that the board were astute to satisfy themselves of the viability of the transaction before they entered into it. And I've referred you to paragraphs 48 to 52 and 119 of the decision. And we've looked at the minutes of the board meeting. Now, Mr. Cashel did not give any evidence, as I've said, as to the purposes of LLC 5 and the loans being commercial. What he said, we would summarise as follows. Firstly, there was no concern over commercial viability of the company. Secondly, the transaction would have proceeded if tax relief had disappeared at the last minute. And thirdly, in making his decision to approve the transaction, he considered that his fiduciary duty was satisfied. And we would say there's no evidence in any of the findings by the tribunal that an object of the company entering into the transaction presented was a commercial, that is, to make money. The evidence was much narrower than that. It was the terms of the transaction presented were such that the directors could approve entering into it without breaching their fiduciary duty. In other words, it's a proper transaction to enter into. And we say that evidence does not support a finding, a very brief finding, that there was a commercial purpose. We say that the correct analysis is set out by the Upper Tribunal, although we talk in terms of commercial purpose. In paragraph 194, that the commercial purpose in inverted commas was a byproduct or consequence of the tax-driven decision. In other words, go back to what I said, it was incidental. It was incidental to the true purpose of the company entering into the transaction, which was to obtain the tax relief.
194 is part of the discussion of just and reasonable.
It is, but they say, and I agree, and at that stage they have they have rejected our appeal on commercial purpose, so they refer to commercial purpose.
Just checking.
Yes, no, you're absolutely right. But in dealing with this, they say that it was a byproduct or consequence of the tax-driven decision. We say that is correct, and that should lead you to the conclusion that it's not a commercial purpose. It's not a purpose.
When dealing with the Edwards and Bairstow point at 147148, one sees the arguments that were being put.
Yes.
That lie behind 194. This is the reference to Mr. Cushell being probed about what the commercial purpose of this was.
147, yes.
147148.
Yes.
What does the management of passive investments involve?
I think it just involves collecting the dividends and paying the interest. Presumably you have to pay the interest on the loans. And then, I mean, the answer is it's hard to think of anything really apart from receiving the dividends that are paid on the shares, and then using the money either to part of the money to pay the loans that you have, and part of it would be dividended up the group. But that's not part of the business. I agree. That's why we say that this is not a commercial purpose. The business was simply holding. If it was a business, was simply holding the preference shares and receiving the dividend.
Well, I mean, I don't want to stray beyond the framework of the case, but in a sense, if you're right about that, it's actually an uncommercial purpose, because all it does is create extra stages of a process.
If you look at it from the group's perspective, that's right. If you look at it from the company's perspective as a standalone, which is how BlackRock are portraying it,
yes,
then the company is just focusing in on.
Yes, but even if one looks at the company alone, I mean, I have no vision as to. I mean, they've got an address in King William Street or whatever it is, but I have no vision as to whether anybody actually happens there. I know that there are 2 or 3 board meetings a year, and whenever other meetings are necessary.
Yes.
I mean, whether one looks at it through the narrow focus of the LL5 C5 alone, or in the company structure purpose, it's perfectly clear what your submission was.
Yes, and what we know is that there's nothing to do. They're not even involved in the dividends because they don't have any control over them. So they have no decisions to make as to what dividends are paid to them. We know that. They simply receive them exactly. Those are the facts. So I think I've now dealt with all the topics on allowable purpose. So unless there's any other questions.
No, thank you, Mr. Hewitt. Yes. Now, should we just take stock?
Yes.
It's always lovely to see everybody, but if we don't need to be here tomorrow, we don't need to be here tomorrow.
No.
And in a sense, you have an hour.
Yeah.
If there are, there were a couple of documents that you were going to supply us with, but I don't think we need to come back in person for that. How would you like to proceed?
I think I can finish in an hour.
Well, obviously, we'll hope you can, but deal with everything as it seems best to you.
Yep.
So, do you want this?
I think it. So there is a point which my Lord Justice Peter Jackson made about me suggesting that there was a change of ground on the part of HMRC. That was particularly addressing their submissions on transfer pricing. As,
Thank you.
and I think I've explained that before the FTT, there was no discussion of this point whether you can, or it is permissible to postulate a third-party company.
Okay, I'm sorry
Is
if I
that-
got that one. That's helpful, thank you.
But I mean, just in terms of, so to be clear, in terms of unallowable purposes, HMRC's statement of case was that Section 441 does not, sorry, Section 442 does not say it's got to be the company's purpose. It can be somebody else's purpose. It could be, they suggested, even the lender's purpose that you take into account. It can be the group purpose. When we got to the FTT and the skeleton argument for the FTT, HMRC by then had shifted their ground to looking at travel document service and saying, rightly or wrongly, as a matter of interpretation, it's got to be the company's purpose. But they were still saying that you can determine the company's purpose by reference to all sorts of other evidence. Fair enough. Now, what they didn't ever suggest in my submission in relation to the alleged tax purpose of the directors of LLC5 was that they intended or desired the tax consequence. That was never an argument. So far as I can see, we've looked at the transcript and their the FTT and their own skeleton argument. It was never suggested that the directors intended or desired that consequence. The argument on part of HMRC.
Didn't say they desired.
Oh, okay. Well, or intended. So Mr. Hewitt says, yeah, I didn't say they desired it, but neither did he say they intended it. Because what we're looking at here is whether what evidence the FTT had and what the arguments were before it. The argument before the FTT in terms of the subjective purposes of the directors was based upon Maloney and Drummond. There was no challenge to the directors as to what Mr. Cushell said was in their mind or anything like that. It was a Maloney and Drummond based argument.
So are you saying it was never, for example, put to Mr. Cushell, well, you know, you spent half the meeting discussing tax. You must have intended this.
My recollection is I don't want to say anything. I don't have a complete record in my head of what was said in, but my submission certainly is that it was not put to the FTT that they intended or desired that tax consequence.
Do we have the transcripts, the relevant transcripts?
You do not have. They're available.
Well, I happen to still have open Para 147 of the UT, because it just happened to be there, but that tells us that Mr. Michel was asked by Mr. Hewitt what were the advantages, apart from the tax advantages. And I appreciate that that's not quite the same thing as saying you wanted the tax advantages.
Well, no, that wasn't actually the question he was being asked, because that was in the context of him. Do you remember I took you to Mr. Cushell's witness statement where
Yes.
he said, I've been asked about the purpose of LLC5 and also about the purpose of the board at the board meeting. Now, in relation to the purpose of LLC5, one of the things he said was we were facilitating the acquisition. Well, that was what the company was doing. And that was what he was put to him. In what way, apart from tax, was the company facilitating the acquisition? So this wasn't put to him in terms of what was in your mind.
But isn't it, I mean, aren't the two things, one has to be analytically pure, I understand, but aren't those pretty much cheek by jowl?
Well, they could be, but
I mean,
nevertheless...
they are cheek by jowl, aren't
Well,
they? I mean, what are people doing here?
Right.
I mean, it is, and so, I mean, I'm sure you're right, because you're not being politely corrected that, that nobody said to Mr. Cushell, you wanted this. Maybe it's not a grown up enough question. in this context. It's obvious.
Well, in any event, it wasn't submitted to the FTT. They weren't invited to find as a fact that the directors intended or desired that consequence. And my submission is, if I can go straight to it, in terms of Malloy and Drummond, the only ground on which the FTT decided that the directors had a subjective tax purpose was Malloy and Drummond. It was not based, as Mr. Ewart suggested, on a combination of Malloy and Drummond and their intending that consequence. That was not put as a proposition.
So the distinction can be drawn between inevitable and intended.
Yes.
You're addressing intended.
I am.
And you're asking us to understand that that was never the revenues case.
That was not the revenues case. It was simply in terms of inevitability. And in terms of inevitability, perhaps I can go there now. Or perhaps you'll recall that in Malloy and Drummond, Lord Brightman said that purpose must be distinguished from consequence, including, he said, inevitable effects. So even though effects are inevitable, and that was the example given of the surgeon going down to the south of France, it's inevitable you're going to enjoy yourself, but that doesn't necessarily mean it's one of your purposes of going down there. So there is that distinction, that conceptual distinction. And in my submission, the argument that simply because directors of a company know about the advantage or are aware of it, coupled with the legislation saying you will get that tax deduction, in other words, that inevitable consequence, cannot of itself mean that that must have been one of their purposes. Subjective
Awareness and expectation do not amount inevitably to purpose.
Yes. And while I'm on that point then, in the Vodafone case, when Lord Justice Millett talked about consequences, he said some consequences. And in my submission, he was making his propositions based upon Malloy and Drummond and the McKinley case. So some consequences, I would submit he had in mind the sort of factual scenarios that Malloy and Drummond and McKinley were about, where, as I've put it in my opening, the private purpose is logically part of your business purpose. You may not consciously go through the logical steps, but it's, I don't know what it's called now, is it a hidden premise or something like that? In any event, it's there as part of your logical reasoning, if only you would articulate it.
Yeah, presumably you would accept it's not limited to private in the sense of personal individual, because as Vodafone shows, it could be, for example, the purposes of another member of the group.
Right.
So it's not personal.
No, sorry, but
not non-relevant. Or
yes, it's certainly not applicable, I would submit, to a consequence that's imposed by statute in the context of sections 441 and 442, because that would mean, if that were right, simply because the directors are aware of the tax rules, coupled with the fact that the deduction is inevitably given by those rules, it would mean that it's always a purpose of the directors and therefore the company to obtain that advantage. And all you're left with then is, okay, it's a purpose, is it a main purpose? And then you're looking at importance. And in a case where the tax involved is a significant amount, it's going to be an uphill struggle to say that it wasn't. If it was one of my purposes, how can I say it wasn't an important purpose, given how much is involved? That in my submission cannot be what the legislation was saying, but it's always going to be one of your purposes if you're aware of the tax rules. The sole question is whether it's a main purpose. Could I think those are probably... Well, a question was asked by Lord Justice Nugee as to how you determine what someone's purpose is. And Lord Justice Nugee said, well, isn't it really as to why you decided to do it? Mr. Ewart said, well, why the directors decided to do it doesn't tell you what their purposes were. I don't understand that proposition. It seems to me that Lord Justice Nugee was right, that the reasons that you have for doing something, I'm not talking about motives necessarily, but what you have in mind as to what you're trying to achieve, as being why you decide to do it, are your purposes. So it's a perfectly reasonable way of testing what your purposes are, to say, why did you decide to do it? And except in those, I would submit, exceptional cases, the Malady and Drummond type cases, you would determine what your purposes are, why you decide to do it, by reference to what consciously is in your mind. And that is why, in Malady and Drummond, Lord Brightman said, except in obvious cases that speak for themselves, it involves what's in the mind of the taxpayer. That is the inquiry. Obviously, that can only be determined objectively by reference to evidence and so on, but that is the issue, what was in the mind of the taxpayer, rather than some sort of objective test based upon consequences.
Do you accept Mr. Ewart's proposition? There's a difference between what your purpose is in answering, in entering into a transaction, and the consideration in the exercise of your fiduciary as a director, whether it's in the interests of the company to enter into the transaction. He said those were two different things.
He did say there were two different things. I can imagine a situation where someone says, this is why I'm going to do it. I better check that I can properly take that decision on a fiduciary basis. But actually I'm doing it for another reason. Let's say I'm doing it to help the group. And I just want to make sure it doesn't damage the company. I can see there's a difference between the purpose for which you're doing it and checking on your fiduciary duties. But the evidence before the FTT went further than Mr. Cushell simply saying, we simply ensured that we complied with our fiduciary duties. And that's perfectly clear. Although he said one passage in the FTT decision, additionally, Mr. Cushell said we checked on our fiduciary duties. That wasn't the sum total of the evidence before the FTT. And that is a point made by the Upper Tribunal when it rejected the Edwards and Bairstow challenge to commercial purpose. It was more than, I don't know whether I'm missing your lordship's point.
No, that is the question. Yeah.
I accept that simply determining your compliance with your fiduciary duties does not of itself tell you what your purposes are. But that wasn't the sum total of the evidence before the FTT.
The FTT did have evidence because we were taken through it by Mr. Ewart in the shape of the board minutes, that quite a lot of the considerations articulated at the board meeting weren't about whether it was a proper thing for the company to do, but were about what the tax consequences would be. Does that not raise a question as to whether that was not one of the things in the director's mind?
It does, and it's a perfectly good point to have made to the FTT and to the witnesses.
But it's not a good point for. It's not for us to find.
No, it's not, because that is island hopping in my submission. That is challenging the FTT's decision on the facts based on all the evidence before it.
But the FTT did decide that it was one of the main purposes. So we're left with this position. The FTT makes a finding of fact that it's one of the main purposes of the director.
Yeah.
You accept that there was material which might have justified that conclusion.
Yeah.
Your criticism, accepted by the Upper Tribunal, was that that was not the basis on which the FTT got to its conclusion.
Yes.
And then you also challenged the Upper Tribunal's decision, who said, well, they didn't get to it the right way, but they were entitled to get to the destination.
Yes, I would put it this way, that based upon the findings made by the FTT, if they hadn't considered Mallow and Drummond, they would have said, right, there is no subjective tax purpose, but there was a commercial purpose. And it's that sentence of the FTT decision where they say, however, we have to go beyond their conscious subjective purposes.
And you say that's where the error is.
That's where they went wrong. So, but for that error, it's clear in my submission that the FTT would have said, subjectively, in terms of what the purposes of the directors were, there was only a commercial purpose.
Thank you.
Can I just note, because no doubt we'll think about this, but you've commended my lord's comment on what purpose might entail. I think why decide to do something. Mr. Ewart's formulation was, what are you trying to achieve? And I'm not going to throw out examples from common life, but one can see that there would be situations in which the two were not quite the same.
They could be different, but if I were to ask my Lord to ask Lord Justice Nugee whether why I'm doing it is any different from what I'm trying to achieve, I would suggest there is no difference, but there could be. It's the difference perhaps between purposes and motives.
Yes, I mean, I just didn't want to leave things lying without seeing that remains for us to think about.
Okay, thank you. There was a point about whether the Upper Tribunal remade the decision of the FTT. It clearly didn't. It had no power to do so under Section 12, I think it is, of the Tribunal's 2008 Act. They only...
2007.
Sorry, 2007.
Tribunals, Courts and Enforcement Act.
I do apologise. They only have power, the Upper Tribunal only has power to remake the decision or remit it if they've identified an error of law.
And I would go on and say, and have decided to set
the decision aside.
Yes. That is expressed.
Yes.
So what was the UT doing? Because they did find that the FTT had placed inappropriate reliance on Mallow and Drummond. And then what did they do?
Well, what they did was
exercising their power to remake.
So what they said was that the FTT was entitled to come to the conclusion that it did, but not for the reasons that it gave. And then in my submission, the Upper Tribunal said, you should look beyond the subjective purposes of the directors for those two reasons that I discussed. And if you do that, and this is for the purpose still of identifying the purposes of the company, if you do that, you'll see all sorts of evidence before the FTT that this was all being done for tax reasons. Now, what it was doing, I would respectfully submit, is that it was making its own findings of fact without any power to do so.
It's not what it was ostensibly doing. What it was ostensibly doing was saying there was plenty of material on which the FTT could make its findings.
Yes, it was, but in circumstances where that finding was based exclusively on Mallow and Drummond, if you say they're wrong to have made that finding.
Yes.
In fact, I mean, we haven't been to Section 12 of the 2007 Act, but we do
have it in the bundle. We do have it in the bundle.
We do have it on page 4 of the authorities. I'm sure that nothing is likely to turn on it, but when one works through it, my lady is right to say that if the UT was in fact remaking the decision, it has to set aside the First-tier Tribunal, that's 2B2. So it's a precondition to remaking that you set aside.
Yes, it's a consequence of, if it does.
Consequence of error of law,
yes.
Under 1. But then if you go to 4, if you are remaking under 2B2, then in fact 4B you can make such findings as think appropriate.
Oh, yes.
So, I mean, I'm only being pedantic.
Well, I'm not sure I'm being pedantic because, yes, you can...
No, but I think your point, I was just thinking about your point, which is they did something they had no power to do.
Yep.
And if that meant jurisdictionally, then clearly they did, but yours is a different point.
Well, I'm not sure mine is a different point.
Right.
My point is that they did not set aside the decision, and therefore they did not have power to remake the decision.
Oh, I see.
And therefore they did not
the
have
same.
power to make those findings of fact.
Right, well...
So they could have done it, but they would have had to go down a different procedural route, set aside the decision for error of law, choose to exercise their power to remake the decision, and then make findings of fact.
Can I just get this right? I'm not saying this case turns on this point.
No,
Simply picking up the question
Yes.
whether actually they remade the decision.
Well, where is the best point to revisit just to see what they thought they were doing? Because
Yes.
the possibilities are either that they thought they were setting aside the decision but forgot to say so, if they then went on to remake the decision.
So if we go to paragraph 162 of the UT decision,
Thank you.
this is page 128 in the bundle.
We should start at 161, because there they say
Yep.
they misapplied the test.
Yes.
Right.
They
So
misapplied the
162 is the sort of 12 subsection 1.
Yes.
Lily pad has been reached.
We're not satisfied there was any material error in the FTT's finding that LC5 also held a tax advantage main purpose. So that they're going to the FTT's conclusion, as it were, that there was such a purpose, having decided that they shouldn't have reached that conclusion based upon Mallory and Drummond, and then saying, but there was evidence which the FTT did not find as a fact in some of the points that are made here. But that's not a very important point. Perhaps it was all pretty clear, which could have justified that decision.
Well, going back then to subsection 12, they identified an error of law in the Mallory sense, and they then could have, under subsection 2A, set aside.
They could.
But they didn't need to do so.
They decided they didn't need to.
Right, so does the trail go cold at
Well,
12
it doesn't
2A?
quite go cold because the Upper Tribunal bases its decision upon
Well, it's explaining after that why it doesn't consider the error to be material.
as I said, I think maybe I'm making more of this point. I began simply by trying to say that they didn't remake the decision. So I'm not...
I think my point is simply that you don't get as far as section 12, subsection 4, which is the power to find facts, unless you are exercising.
So 12.2 seems to be for cases where there's been a mistake, but that it doesn't really matter. They got to the right decision for the wrong reasons.
Well, that is obviously that's not my submission.
No, of course.
But just looking at that point, what they then do is, and they say they're doing this, is looking beyond the subjective purposes of the board. And that's my criticism of the Upper Tribunal.
So just remind me where you say they say that.
162,
Okay.
second sentence.
And 166.
Yes. And when they, remember I said yesterday, when they say stated motives or intentions, they don't mean purported, what they asserted. It's as stated by the FTT. So it's looking beyond the actual, if I can put it that way, motives or intentions of the board members to determine the company's purpose.
Well, I'm not sure. I'm not sure that that's obvious. It's clearly an ambiguous word stated, but it could equally, I know you've been there before, be asserted.
Well, it could be, but...
I mean, and asserted and not doubted.
Well...
I mean, in the sense...
Well, there's certainly, if we look at what's said at 164 and 165.
So did I say asserted? What I meant when I asked you this question was expressed. The expressed motives. What was in the statements, what was on the minutes?
Well, in my submission, by going beyond the director's stated intentions, first of all, the Upper Tribunal doesn't mean asserted, first of all. Secondly, I would submit it's not simply saying expressed as opposed to implied. Can I pick it up, try and support this point by a paragraph that I referred to earlier on, paragraph 191. A travel document service confirms that the question of whether there's a tax avoidance main purpose is primarily to be decided by reference to the subjective intentions of the directors of the company. And my submission is, when the Upper Tribunal says primarily, it's got in mind that that's not what it was doing when it referred to looking beyond the stated purposes of the company. And look at 164. The second sentence of 164. As a result of this advice, the stated subjective intentions of the only director to give evidence were circumscribed. Now, that is not saying his expressed intentions were circumscribed. It's saying that his intentions were circumscribed and cannot represent the nature of the director's intentions. And again, it's looking at actual, implied, or expressed, or whatever, had they been left freely and willingly to decide the main purposes of the transaction. So what the Upper Tribunal is doing is not merely going beyond their expressed intentions to their implied intentions. It's going beyond their intentions altogether because their actual intentions are circumscribed. And then likewise, 165. The effectiveness of anti-avoidance legislation cannot be undermined by tax advisors telling parties to ignore the tax advantage purposes of a transaction, and so on. To hold otherwise would provide an easy way around the legislation. Again, they're not saying you could get around the legislation by saying, not expressing it, but implying it. Because of course, if it's part of your unexpressed purpose, then that's something for the FTT to decide. What they're saying is, you can't be stuck in looking at the purposes of the company with the director's actual subjective purposes, expressed or implied, because that would undermine the legislation. My submission about that, as I've given already, is, first of all, it overlooks the point as to why these directors left tax out of account. And secondly, there is no warrant in the legislation for bypassing the actual expressed or implied intentions of the directors simply because on the grounds that looking at them might undermine the legislation. Parliament is happy to focus on the intentions of the directors on the basis, it assumes perhaps, that these will be properly tested before the FTT and facts rigorously found. And I know I've made this already, but that's where, from HMRC's point of view, this case has gone wrong. I think that's all I need to say about unallowable purpose. If I can move on to transfer pricing. Well, I began my submissions, or in fact my submissions about transfer pricing were very largely focusing on what the Upper Tribunal had decided, which is that if you take third-party covenants into account, you're altering the substance and the materially relevant economic characteristics of the transaction. Now, in a sense, I haven't got anything to reply on that because Mr. Ewart said nothing about that at all. His focus on transfer pricing was simply, if I've understood it correctly, that you cannot postulate third-party covenants if they don't exist in the actual transaction. Full stop. Now, if one asks, where does that rule come from? He says it comes from section 147, subsection 1, A and D, which talks about transactions between two persons. And therefore, he says, because you've got to focus on a transaction between two persons, you can't postulate the involvement of anybody else. Now, that argument immediately breaks down when you see section 1525 saying you can't take account of a guarantee given by a third person. Now, Mr. Ewart tried to argue, well, that if you have a subsidiary being guaranteed generally, that's all part of its circumstances, and somehow that doesn't breach his rule. Lady Justice Falk said, well, how about a case where a guarantee is given specifically for the transaction? And he accepted, yeah, that could happen. But he said that somehow, well, his answer to that was, well, the only thing that 1525 is aimed at is where there is an actual guarantee, and it's telling you can't carry that across to the hypothetical transaction. But he's therefore admitting that this two-person rule does not forbid the taking into account of third-party involvement. It's 1525 doing that in a particular circumstance. So this supposed two-person rule which says you can't have third-party covenants, in my submission, is plainly wrong in the light of 1525, and indeed 152 telling you to take account of all factors. But the next point about that is, I've taken you to this already, the experts were agreed that in virtually every big independent lending transaction, the lender will insist upon covenants making sure that the income is not going to be diverted. It will require covenants from various members of the group, even though it's lending just to one of them. But they said, you don't normally see this between companies in the same group. They don't need it. Now, if it's right that you can only take account of third-party involvement in the hypothetical transaction if it exists in the actual transaction, then the immediate problem is, well, what happens then in that sort of situation? Mr. Ewart said, well, this sort of problem doesn't really arise very much. It's because, as Lady Justice Falk said, the revenue don't take that point. They don't argue this supposed two-party only and no third parties. They don't argue that point. The reason they don't argue it is because it's a bad point that they're only raising now as part of their attack on what they perceive as a tax avoidance transaction. So it's a bad point in my submission. It cannot be right that the legislation forbids companies which don't in practice have such covenants from getting tax relief. Another obvious example would be, surely an independent lender would require some sort of covenant from the subsidiaries, which have actually got the business, making sure that they don't put the money somewhere else or borrow somewhere else.
That is the sort of covenant I was referring to.
Right. But that subsidiary covenant is a third-party covenant because the loan is not to that subsidiary, it's to the intermediate holding company. So that breaches this two-person rule, according to Mr. Ewart. Now, the only possible answer to it is, well, that's a problem for you groups. You've just got to make sure that you have it in the real world, because then, according to the revenue, you can postulate it. But we've seen from the Upper Tribunal what it thought about that, and it cannot be a requirement of the legislation to put that unnecessary formality onto groups, because the transfer pricing legislation is all about the economic position, not formalities. So I would submit this whole argument on the part of HMRC, this transfer pricing attack, is merely a sort of an add-on to their real attack, which is unallowable purposes. And whatever the outcome of the unallowable purposes point, I would submit that the only possible answer is that the transfer pricing point is a bad one. I did want to pick up, Mr. Ewart relied on a paragraph in the, I think it was the 2022 Transfer Pricing Guidelines, page 925. Could I please take you to that?
Yes.
This is at the bottom of page 925, paragraph 10.19, which says independent enterprises, when considering whether to enter into a particular financial transaction, will consider all other options realistically available to them, will only enter into the transaction if they see no alternative that offers a clear, more attractive opportunity to meet their commercial objectives. Now, I don't know why Mr. Ewart mentioned that, because it's no part of their case anymore that this transfer pricing question should be looked at from the point of view of the BlackRock Group as a whole. In other words, the question isn't, is it commercially rational from the point of view of the group as a whole for LLC 5 to be the borrower? That was a point which they advanced in the FTT and was rejected, and was advanced again in the Upper Tribunal and rejected, but was not subject of their respondent's notice to this court. So it's not a point that's live anymore. But the real point is, paragraph 10.19 is itself saying independent enterprises will consider all other options realistically available to them, not to the group, but to the enterprise itself. And so one looks at it from LLC 5's point of view, and from LLC 5's point of view, there was no alternative transaction realistically available to it. I mean, there was no other way it would have $10 million worth of funds in order to subscribe for shares in LLC 6. This was the deal on the table. I think I've made my submissions on transfer pricing now, and it's only I think, if I may say just a couple of things about the attribution test, and then are you going to make? Yeah. Mr. Yates will make a very brief reply on what Ms. Chowdhury said, if that's possible.
Yes, thank you.
So, in terms of the attribution test, I think I've already made my submissions on that in my 15 propositions. But just to recap, when you go to section 441. The question you're being asked to consider is, to what extent the debits are attributable to the unallowable purpose. So the focus is on the unallowable purpose that you've identified under 442, which is common ground, is a subjective purpose of the company, meaning the subjective purposes of the directors.
I think that's, I think you're making a submission about that.
Okay. Well,
but actually, I'm fairly sure that the focus is on attributability.
No, but the point I was making was the question of what the unallowable purpose is we've decided under section 441, it's a purpose of obtaining a tax advantage of the company. It's a company's purpose, is the unallowable purpose. It's nobody else's purpose. When you go to 441 and ask to what extent are the debits attributable to that purpose of the company, of its directors, in my submission, you can't answer that by saying, well, it is because somebody else had a purpose, a tax purpose, in creating the company. That is not the focus of 441. It's about the causal consequences, the causal effects of the director's tax purpose. And if you ask what's the causal effect of the director's purpose, you can't answer that by saying something like, well, the company only existed for tax reasons. That just doesn't deal with the question. It doesn't answer the question. It's giving you a different answer altogether. So, of course, it's about attributability. And that is an objective question. A question of what would have happened but for that purpose. But in my submission, it's still asking, would the board have decided to enter into the transaction anyway, but for that purpose? Because it's in my submission, it's about the competing purposes that you might have found. Obviously, if the only purpose is the unallowable one, the answer is clear. But if there's another purpose as well, a commercial purpose of the company, you've got a question of, at that point, of apportionment. But you're still answering the question by reference to those purposes of the company. You don't throw in, lob in, as it were, and something that you weren't interested in under 442, which is why the company, somebody created the company in the first place. That is not part of the exercise in my submission. So attributability is, yes, it's objective, but it's trying to work out the causal consequences, the relative causal consequences of the two actual purposes of the company that you've identified.
Well, it's apportionment between those purposes.
Right.
But I think is what you're saying.
I'm saying it's apportionment between those purposes, and you can't decide that question of apportionment by saying, well, this is all very easy because the company wouldn't have existed but for someone's tax decision, because that is moving away from apportioning between those purposes to something else altogether. So that's my submission on that, and then Mr. Yates will briefly say something about if that's possible. Yep.
Just in relation to the question of apportionment, just in terms of the follow-up points in relation to my submissions, two very short ones.
Thank you.
Ms. Stewart said it wasn't really a matter for this court. That's obviously wrong as a matter of jurisdiction. Parliament, in its wisdom, has afforded you a fact-finding function if you choose to take that up under Section 14, and you've already had the discussion in relation to Section 12. Well, Section 14 essentially mirrors that. Simply because you have jurisdiction doesn't mean it's appropriate for you to exercise it, however. But one has to ask, unlike many other cases where remittance to the First-tier Tribunal is appropriate, what advantage is the First-tier Tribunal going to have over this panel in deciding matters? We've only relied on 3 documents which were never in dispute. Some were actually agreed before the hearing. That's the sum total of what LLC 5 is seeking to rely on for the purpose of apportionment. So that's dealing with the not a matter for this court point. Second point is no principled reason to refer to the factors. Mr. Hewitt's examples all make sense if you only have a tax purpose. So it's no answer to say, well, the interest rate's gone up, therefore that doesn't get disallowed, etc., or the law has changed. But what this court is going to have to grapple with if it comes to this stage is, as Mr. Prosser says, you're trying to weight between 2 competing factors. And therefore, one has to try and look for a tangible basis to try and carry out that weighting. That is ultimately what we have tried to do with our 2 alternative submissions on that. I think that's what I want to say by reply on that. Very briefly on the expert's evidence, actually, as Ms. Chowdhury's points. There are really 2 points at play here. The first is it wasn't agreed between the experts as to the nature of the preference dividend covenant. The second point is Mr. Gaisford's cost and complexity point. Now, you've been taken to various parts of the transcript in respect of the expert evidence, and this is really just a point of housekeeping and assistance. There is, if I may say so, a reasonably useful summary of all the expert evidence, written and oral, in LLC 5's skeleton argument for the UT, starting at paragraph 98. I don't need to go to that now. You can find that in Supplementary Bundle, tab 15, page 309. The other introductory comment I would make is that obviously the revenue have taken you through various parts of the transcript for this or that snippet of expert evidence. But in my submission, that comes nowhere near meeting the burden of an Edwards and Bairstow challenge in relation to the FTT's finding in relation to expert evidence. Ms. Chowdhury's fallen into the usual trap of island hopping, as described by Lord Justice Lewison in the FIA and Chobani case, which is recited, just for your note, by the Upper Tribunal at paragraphs 135 to 136. So just coming on to the substance, the dividend covenant. It's common ground, as I said in my opening submissions, that Mr. Ashley and Mr. Gaisford saw the covenant, the required covenant, in different terms. Apart from one moment in his evidence, which Ms. Chowdhury is taking you to this morning, that was on day 3, transcript page 38, which is on page 201 of the supplementary bundle, Mr. Ashley was consistent in terms of how he saw the covenant.
Sorry, can you just give me that reference? again, supplementary bundle, page
201.
Internal page.
Internal page 38.
Thank you.
So first of all, there's the joint statement, which I took you to an opening. It's set out in the FTT's decision, I think at paragraph 77. The joint statement described the covenant as merely to effectively ratify the legal and financial position to which the appellant was entitled. I emphasise that word in opening. So Ms. Chowdhury sort of mocks Mr. Ashley's position, or well, it doesn't really add anything to what the LLC 5 is already entitled to. But that was the position in the joint statement. What you haven't been taken to, and I don't think I need to take you to now, but it's certainly worth your consideration, is Mr. Ashley's second report, which followed the joint statement. The whole report was him explaining the exact nature of the covenants he envisaged and why it wouldn't be unduly costly or complex for that to be provided. And that is found at Supplementary Bundle, tab 8, page 140. And in particular, I would encourage you to read paragraph 10 and then from paragraph 17 to the end. That essentially describes what Mr. Ashley's there really getting to grips with is what exactly am I talking about in terms of the covenant. And again, he accepts at paragraph 20 that it doesn't add really much more than the entitlements of LLC 5. And then his conclusion as to why that didn't add much by way of cost and complexity. Mr. Gaisford, obviously in his oral evidence, did, and you've been taken to this morning, say that what Mr. Ashley was envisaging wasn't going to be good enough from his point of view. Entirely accept that. But, this is not being disputed, he did affirm what he said in the joint statement, i.e. those covenants would be forthcoming, subject to, of course, his cost and complexity point. And so that is the red and blue covenant point, which I alluded to in my opening. And that is why, respectfully, the Upper Tribunal was completely correct to dismiss the appeal in that respect, in paragraphs 82 and 85. The high watermark of the revenues case is that in its recitation of all the evidence, and it certainly recited a lot of the expert evidence, the FTT did not spell out Mr. Gaisford's own take on what the required covenant was, as per his oral evidence, as opposed to what was sent out in the joint statement. That clearly was not going to be enough to disturb the finding. So if I may just turn to the cost and complexity point, that's the last point. It's important to note here that the cost and complexity that Mr. Gaisford is referring to is the cost and complexity for the BlackRock Group. It's nothing to do with the lender. He makes that very clear in his cross-examination. That's on day 3, internal page 80 to 81. The reference for that is Supplementary Bundle, tab 11, bundle pages 211 to 212. And that is, in my respectful submission, accurately summarised by the FTT at paragraph 74. And Mr. Ashley's position is also briefly summarised at the beginning of 74. So you have two competing views on this cost and complexity point. There is the FTT obviously preferred the evidence of Mr. Ashley on that, made a clear finding that it was preferring the evidence of Mr. Ashley. There is no basis for interfering with that factual finding by the FTT. And again, the Upper Tribunal was completely correct to hold the same as it did at paragraphs 86 to 88. In any event, even if there was something in this cost and complexity point, which essentially is it would have been rational, it wouldn't have been rational for the BlackRock Group to burden itself with all these covenants. It should have just borrowed higher up the group. This was really a question of law in how one applies the transfer pricing legislation. And this was an argument, as I said, which was run by the Revenue before the Upper Tribunal. This is their ground 2. They lost on that, and they haven't appealed it.
This is you can look beyond LLC 5.
You have to ask, well should BlackRock have borrowed through another company?
So
where it would
revenues ground 2 in the Upper Tribunal.
Revenues ground 2 in the Upper Tribunal. And given that they haven't appealed that, and it's particularly paragraph 92 of the Upper Tribunal, given they haven't appealed that ruling, what is completely left unexplained is how this point is relevant in any event. But just to sum up, the FTT looked at the competing evidence, preferred the evidence of Mr. Ashley. in any event, even if it had erred in law, and it's very difficult to see how it could have, the point really goes to a legal point rather than a matter of evidence in any event. Yeah, it's no longer in play.
Are we on the same page? I mean, you took us to Mr. Ashley's second statement, which I was just...
I haven't taken you to it, I've given you the references.
No, exactly. Well, I was just reviewing it while you were talking about it. And basically, his view was that additional costs would be limited to professional advisors' fees, costs of drafting, agreeing, additional documentation, and some management time. Is that, we're talking about the same thing?
Well, let me, since we're there.
Page 146.
Yes, let me just...
in the supplementary one. I'm conscious I may be picking out something that refers to a different point.
No, the point, so there's two things. The literal cost of it, that's not really Mr. Gase's point.
Yeah.
The point, which is Mr. Gase's point, is the unwillingness of the other companies within the group to play ball, as it were. And Mr. Ashley addresses that at paragraph 21.
Right, and in any case, in the context of a transaction of this sort, Mr. Ashley's evidence, which was generally favoured, was that incidental costs of this sort, in the context of a deal of this size, were effectively...
Yes, and I don't think Mr. Gaseford, to be fair to him, would disagree with that. It ought to have been completely small beer compared to the amount of the borrowing involved.
Yes.
Mr. Gaseford's point is not that, lawyers' fees would have put somebody off doing this or whatever. It was more to do with the opportunity cost of the group of having to commit to a series of covenants like that, which would restrict its freedom of manoeuvre, for example. There was also a separate point, which really wasn't related to this, which was obviously the general point that there would be a lower cost of borrowing if, say, the parent company borrowed rather than LLC5. That point, in relation to the 40 million, that's not any part of the revenues case on this issue. So the two do blend it together a bit. But as I say, Mr. Ashley addresses that point fairly and squarely. His evidence was preferred. Unremarkable finding by the FTT, which cannot be challenged in this court, as indeed it couldn't be challenged in the UT. I think that's all I can say on the matter.
No. Thank you very much. Very well, thanks to all the parties and their advisors for the notably efficient way in which this appeal has been prepared and argued. We'll take time to think about it and let you have our judgments in due course. It's necessary to say that when the draft judgments are handed down, they are confidential to those who are on the lists for hand down, and in a case of this sort, that is going to be observed scrupulously. We'll be very grateful for your corrections where they're necessary to expression and accuracy, but essentially we'll look to you to provide a draft order that reflects our decisions as closely as possible. If there are any matters of disagreement, we'll be grateful for short written submissions, and we'll then decide those without having to trouble you to return. Mr. Prosser.
May I just ask one point? Does the court be helped in any way by seeing any of the other documents that are not in the bundle? There was a mention of the FTT skeletons.
Yes, well, I think we've already asked for the FTT skeletons. I'm not myself anxious to embark upon other transcripts because we would then be inviting comment upon them as well. But allow me to consult if I may. Yes, LLC 5. Yes.
Oh, sorry, I think it's LLC 6. I raised earlier, I think it's LLC 6. We haven't got the membership agreement. We have a recitation of
We'll provide that.
share
Of that.
rights.
Thank you.
I'm not expecting that to be controversial.
No.
I just prefer to.
It doesn't tell us very much. Better see the thing itself.
Yeah.
Yes. But I don't think unless we ask subsequently, we'll ask for any further transcripts, because you know how when one starts reading into a trial, it becomes gripping and then on you go. So we don't want to get into that process. Good. All right, thank you
very
very much indeed.
All right.